Hello, good people. Welcome back to Global Happenings. Today, we're so excited to have you again. Atiku Abubakar, the presidential aspirant of the People Democratic Party, has dispelled the fears that Bola Ahmed Tinubu, the president of Nigeria, had sent across when he talked about the nullification of the presidential election that took place on the 25th of February 2023. Bola Ahmed Tinubu, in his written address, had told the judges and Nigerians that in event of nullifying the elections, it will result to anarchy. But right now, Atiku Abubakar has dispelled that fears Nigerian had with the reply he sent across to the justices and also to Bola Ahmed Tinubu about the possibility of annulling the election. Now, according to the news, the former vice president and presidential candidate of the People Democratic Party (PDP), Alhaji Atiku Abubakar, has tackled President Bola Ahmed Tinubu over his position that nullifying the outcome of the presidential election that held on February 25th may lead to anarchy in the country. Atiku, through his team of lawyers led by Chief Chris Uche, senior advocate of Nigeria, said he observed that President Bola Ahmed Tinubu, in a final written address he filed before the Presidential Election Petition Court (PEPC), sitting in Abuja, misunderstood the depth of issues that were raised against the election. The PDP candidate, who placed reliance on Supreme Court decided case law, maintained that the heavens would not fall should the court nullify the President Tinubu's election. According to him, and I quote, he said the fact that a presidential election has never been nullified by the courts in Nigeria before now is not a good reason not to do so now, as it is very just to do. In the process he filed before the court, Atiku, who came second in the presidential contest, stated that at this stage it is pertinent to observe from the outset that the second respondent final written address with respect to reflection a complete misconception and unfortunate misunderstanding of the case of the petitioner, notwithstanding the magisterial arrogance, condescending cynicism, and overbearing misanthropy with which he had sought to trivialize the petitioner's case, as will be shown hereunder. Furthermore, a subtle trait of apocalyptic catastrophe of national chaos and anarchy, if a judgment is not given in a particular manner, cannot deter a court of law from doing justice. The court must do justice, rather let the heavens fall. But as courageously stated by the Supreme Court, Pe Oguntaye JSC, in the epic case of Amechi versus INEC and QRS 2008 LPELR 446 SC, page 67 to 68, paragraph, I must do justice even if the heavens fall. The truth, of course, is that when justice has been done, the heaven stays in place. It is also pertinent to observe that the final written address of the second respondent was filed in flagrant defiance of and non-compliance with the mandatory provision of paragraph 5 subsection C and D of the Electoral Judicial Proceeding Practice Direction 2023, rendering same invalid. We urge your lordship to discountenance as well as strike out the said final written address for gross non-compliance. Alleging that the Independent National Electoral Commission (INEC) clearly mismanaged the election as shown by evidence, the former VP said the sole weakness the electoral body produced before the court admitted that The technological innovation introduced through bimodal voters accreditation system (BVAS) and transmission to the Rev portal was to guarantee the transparency and integrity of the election result. Atiku stressed that despite the innovation, INEC, through its weakness, admitted that there was a technical glitch that made the system to fail to work. He said the weakness, who is a director in charge of information and communication technology (ICT) at the INEC, further admitted that the presidential and national assembly election were held on same day and with same BVAS machine. He openly admitted that at the time the result was declared on 1st March 2023, all the result has not been uploaded to the IREV. He was shown the European Union Observer's final report, which was admitted as Exhibit RA6, and he read out the relevant portion indicting the conduct and outcome of the presidential election. It is instructive to note that despite the uniqueness of the new regime of election management, INEC failed to call even one field officer or agent or staff or any ward collation agent or local government collation agent or state collation agent or poll officials, any of its numerous registration area technicians, or even the presiding officers, assistant presiding officers who handle the BVAS machine, or who persons who operated any aspect of the technological system, including the IREF, to give evidence or to even explain the nebulous technical glitches. Besides, he argued that President Tinubu did not call any weakness in support of his claim of victory in the election, but only one weakness: a certain Senator Okpeyemi Bamidele, who claimed to be practicing law in the United States as well as in Nigeria, and at the same time a serving senator who came to speak on the qualification of the second respondent and admitted that the name of the second respondent is the subject of the U.S. for features judgment admitted in court as Exhibit PBF1. He admitted that the second respondent did not score 25% of the vote cast in the FCT in the election. Atiku therefore prayed the court to declare that the return of President Tinubu as the winner of the election was invalidated by reason of substantial non-compliance with the mandatory provision of the Electoral Act 2022 on electronic transmission of results for collation and verification by deliberate bypass of and failure to transmit the election result electronically. The petitioner have established that the return of the second respondent as the winner of the presidential election held on the 25th day of February 2023 was unlawful and unconstitutional, having not secured 1/4 of the valid vote cast in the FCT Abuja as required by the Constitution of the Federal Republic of Nigeria 1999 as amended. The petitioner have established that the second respondent was clearly disqualified under the provision of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on the 25th day of February 2023, having regard to order of criminal forfeiture on him arising from drug-related offense, his declaration of alliance to a country other than Nigeria, and acquisition of citizenship of another country, and presenting a false certificate to the first respondent. The petitioner have proved that second respondent was not duly elected by majority of the lawful vote cast in the election. The respondent profiles very scanty evidence in defense and virtually abandoned their pleading by not calling necessary weaknesses, not having any credible defense to the petition. We submit with all sense of responsibility that this nation and its judiciary stand at the threshold of history. We submit that the fact that a presidential election has never been nullified by the court in Nigeria before now is not a good reason not to do so now, as is very just to do. As was eloquently put by the celebrated law lord Danning MR in the case of Parker vs. Parker 1954 AC, page 15 at 22, that what is the argument on the other side? Only this, that no case has been found in which it has been done before. That argument does not appeal to me in the least. If we never do anything which has not been done before, we shall never act anywhere. The law will stand still while the rest of the world goes on, and that will be bad for both. May our law and our country no more stand still while the rest of the world goes on, the PDP candidate added in the final brief of argument he filed alongside his party. It will be recalled that President Bola Ahmed Tinubu has earlier challenged the legal competence of Atiku's position, which he said grossly lacked merit. In the preliminary objection he filed before the court, Tinubu described Atiku as a consistent serial loser that has since 1993 crisscrossed different political parties in search of power. He said the first petitioner, Atiku, has been consistently contesting and losing successive presidential elections in Nigeria since 1993, whether at the party primary level or at the general elections, including 1993 when he lost the Social Democratic Party SDP primary election to the late Chief MKO Abiola, 2007 when he lost the presidential election to the late President Umaru Yar'Adua, 2011 when he lost the People Democratic Party presidential primary election to President Goodluck Jonathan, 2015 when he lost the APC primary election to President Muhammadu Buhari, 2019 when he lost the presidential election to President Muhammadu Buhari, and now 2023 when he had again lost the presidential election to the respondent. Further to Supra, is not a surprise and or not by accident that the electoral rejected the first petitioner at the poll of the presidential election held on 25th February 2023, insisting that he was validly returned as winner of the presidential election by INEC. Tinubu told the court that unlike Atiku, he has been the most consistent politician who has not shifted political tendencies and alignment. That was a long read, I must say. But here, one of the things that is being portrayed by the write-up coming from Atiku Abubakar is that no matter what happened, whether it's going to be the first time in the history of Nigeria that the heavens will not fall if the court or the law sees the just concluded election as being totally illegal, or it's considered not to be in sync with the laid down provision of the Constitution. That's what we would like to wrap it